नमस्कार फ्रेंड, आप सभी का स्वागत है। फ्रेंड्स, श्री सी एन वेणुगोपालन सर ने एक मैटर रेफर किया है। पेमेंट ऑफ पेंशन टू श्री के ए पद्मनाभन एम्प्लॉइज ऑफ ई सिंडिकेट बैंक इन कंप्लायंस विद द डायरेक्शन ऑफ केरला हाई कोर्ट इन रिट अपील 1957 ऑफ द 2019। इस बारे में संदर्भ में बताऊं कि finally Canara Bank prepares to pay pension to Sri K.A. Padmanabhan, who was denied pension by Syndicate Bank from 1st May 2010 on the ground that he did not refund the management share of CPF before the stipulated last date of 15th December 2010. The workman director of the Syndicate Bank, who was approached for help, was no assistant in this issue and told that he should be approached only through state level leaders. Writ petition 7321 of 2014 was allowed by Kerala High Court with the direction to pay pension with prospective effects from 2018. When Syndicate Bank declined it, the order was again challenged through fresh writ petition in which Syndicate Bank was directed to pay the petitioner interest of the 2.8 times pay for November 7, 2007, which Syndicate Bank forcefully credited back to the SB account of the employees on 20th June 2013 to defeat his claim for pension. Though the employee abandoned for further legal action, the matter was pursued by me through a writ appeal in 2019. The division bench allowed the appeal on 2nd December 22, directing the bank to pay pension from 1st May 2010. The order did not go into the merits of the case, yet gave a direction to pay pension. Though Canara Bank did not act on it till now and was planning to go for appeal with SC, other steps initiated made them come forward to pay the pension as directed by the Kerala High Court. There are another 186 cases where Syndicate Bank did not pay pension on the same ground and denied justice to employees. This present act of Canara Bank to pay pension is a good indication that employees will get justice in the updating case too, especially in the wake of the false affidavit filed on 24th August 22 and the Kerala High Court order in favor of updating produced before the Supreme Court. इस केस का डिटेल जो सी एन वेणुगोपालन सर ने शेयर किया है और उन्होंने केनरा बैंक के चेयरमैन को एक पत्र लिखा जिसमें लिखा कि पेमेंट ऑफ पेंशन टू श्री के पद्मनाभन को केरला हाई कोर्ट के डायरेक्शन के अनुसार मिलना चाहिए. इट वॉज ए मैटर ऑफ डिस्ग्रेस दैट इन स्पाइट ऑफ द हाई कोर्ट ऑफ केरला डायरेक्टिंग टू पे पेंशन टू द above implies, Canara Bank took the matter to the Supreme Court of India in violation of the National Legislation Policy through SLP number 5357 of 2023. Posthumously to taste the defeat once again, simply as it can allegate at the cost of public money. Canara Bank was following the footsteps of Syndicate Bank, which went into obscurity after committing sins to employees who worked for it. Now I make a humble request to you, be pleased to pay the pension to the employees as directed by the High Court in the following mode to be fair and reasonable. Appropriate 6,551,535 from the fixed deposit towards Canara Bank to bank's contribution to the PF, including management portion of NRW, if any with interest, as directed in para 13 of the order dated 2nd December 22. Pay pension to employees from 1st May 2010 along with the interest at 9% on the pension payable for each month from 1st May 2010 to 30th April 2023. Pay commutation of pension by renocking the age of 60 at the time of retirement, that is the 30th April 2010, and interest at 9% on the amount of commutation from the date. Fixed the date of restoration of full pension, renocking 15 years from the date of commutation. The release of management share of CPF of rupees 6,51,535 by Syndicate Bank on 3rd May 2010 to the employee was erroneous, as the CPF was to be retained by the bank for transfer to the pension fund. It was not taken back when requested to do so, so it can affect no interest apart from its refund. Banks have also not collected anything additional to the 156% of the CPF, even from the compulsorily retired employees, for giving them pension in the year 2018. The provision for payment of the 56% of the CPF was coming into the pension regulation only through clause 3B of the Pension Amendment Regulation 2017, and it is void in terms of Section 19(1) and 19(4) of the Banking Companies Acquisition Transfer Act 1970, it being inconsistent with the pension scheme. The order of the Honorable Court also does not mention payment of anything beyond rupees 6,51,355. Patently, the amount was remaining with the bank itself in form of fixed deposit from the very date of its release, that is 3rd May 20. And the bank was applying the money in its lending activities and earning handsome interest. Grey matter was wanting in the skulls of the blind and the blunt official of the syndicate bank to act in prudent manner. They were departing from the settlement on pension dated 27th April 2010 and stipulating the conditions applicable to both pre-27th April 2010 retirees and the post-2010 retirees to the employees and denying him pension. The bank had recovered 62,440 rupees as contribution to pension fund on 23rd June 2010 from the salary arrears of the employees on the basis of settlement dated 27th April 2010. It later forcefully paid the amount back to 20th June 2013 to defeat the right to pension of the employees clandestinely. The amount is not payable by the employee in terms of the pension regulation in force, and the settlement cannot override the pension regulation. The ruling dated 30th February 2018 of the Honorable Supreme Court in Civil Appeal 5525 of 2012 was Bank of Baroda versus G. Pilani and others is making it explicit that the settlement joint note cannot supplement any of the provision of the pension regulation which is statutory. An option for pension was streaming from the Syndicate Bank Regulation 1998 to the employees, which not given to him. The bank was later betraying him by giving an option on unlawful terms of settlement dated 27th April 2010. Hence, the amount of rupees 62,440 is not payable to the bank by the employee. The provision for the contribution to pension fund are coming into the pension regulation through the Bank Employees Pension Amendment Regulation 2017, and they are void in terms of Section 19(1) and 94 of the Banking Companies Act 1970. It being inconsistent with the pension scheme, the order dated 2nd December 22 of the Honorable High Court is also not directing the payment of 62,440 by the petitioner. Syndicate Bank was virtually putting the employee into starvation for 13 years without giving him pension and enjoying the money as a sequel of its own mistake. The employees had to sustain a loss of 2 lakhs by way of legal expenses also. It would be an act of wisdom to imagine yourself in the place of employee, as it will lead you to the right course of action which are outlined in para 2 above and can obviate inconvenience and further litigation. Pertinently, it to be mentioned that moral turpitude is attributed to an employee who depart from the code of conduct and they are punished. What else is the mode of behavior of the top management of the bank is not paying due pension to an employee for the mistake on the part of bank. To my knowledge, there are nearly 200 similar cases where pension was denied by syndicate bank for failure of refunding of CPF and 56% of it within the time frame 15 December 2010, where Canara Bank can be arrayed into litigation. For the time being, I request to kindly pass a necessary instruction to those concerned to settle the payment of pension to the employees and to the furnish the detailed working of the payment to the obviate filing of the contempt petition before the Honorable High Court at your cost. श्री CN वेणुगोपालन। यहाँ पे दो चीज़ें बड़ी इंपॉर्टेंट है कि CN वेणुगोपालन सर ने इस केस को सेटल कराने में जो पूरी मदद की, जो व्यक्ति 13 साल से पेंशन से डिप्राइव रहा। लेकिन सिंडिकेट बैंक की वर्किंग को देखिए कि अभी भी ऐसा लगता है कि इस तरह के 200 सिमिलर केसेस वेयर पेंशन वाज डिनाइड बाय सिंडिकेट बैंक फॉर फेल्योर ऑफ refunding the CPF and 56% of it within the time frame of 15 December 2010, और उनका छोड़ा हुआ कैनरा बैंक को लिटिगेशन में जाना पड़ रहा है। ऐसे में बैंक को एक 200 जो केसेज हैं उनको उसी तरह की सुविधाएं प्रदान कर देनी चाहिए, क्योंकि बार बार के लिटिगेशन में जाने से बैंक का पैसा पब्लिक मनी है, इसको नुकसान नहीं पहुंचाना चाहिए। Thank you, Sri CN Venugopalan sir. Hats off you to take and settle the case in appropriate manner. Thank you. Namaskar.